All right, good afternoon, everyone. We are excited to start the last panel of the day. So we've heard about the past and the present, and on this panel we will hear about the future of FTC rulemaking. I am joined by an all-star panel. I'll introduce them, and then we will each have opening remarks and then take your questions at the end of the panel. So first, Professor Nielson needs no introduction. Thank you so much for organizing this great event. He is a professor of law at BYU Law School. He lectures and writes in the areas of administrative law, civil procedure, and federal courts. His publications have appeared in a variety of journals, and he serves as the chair of the Administrative and Management Committee of the Administrative Conference of the United States. Next, we have Erin Murphy, is a partner at Clement and Murphy. She is widely recognized as one of the nation's leading Supreme Court and appellate advocates. She has argued dozens of cases in appellate and trial courts throughout the country, including the Supreme Court and nearly all of the Federal Court of Appeals. Erin is one of only 7 women in the top 2 bands of Chambers and Partners rankings for appellate law nationwide, and the National Law Journal has named her as one of the nation's outstanding women lawyers. Next, we have Blake Emerson. He is a professor of law at UCLA Law School. Prior to joining UCLA Law, he was a research fellow at the Administrative Conference of the United States in Washington, D.C. His primary research interests lie in administrative law, structural constitutional law, and political theory. In 2021, he received the Association of American Law Schools Administrative Law Section's Emerging Scholar Award. And finally, we have on the Zoom screen Tim Muris. He's currently senior counsel at Sidley, where he advises clients on all aspects of antitrust enforcement with particular focus on mergers, civil litigation, and strategic counseling. Tim served as the chairman of the FTC from 2001 to 2004 and previously served as both the director of the Bureau of Consumer Protection as well as the director of the Bureau of Competition. So Tim, thank you for joining us. With that, let me turn it over to Erin to discuss what may happen institutionally if the FTC becomes a serious rulemaker.
All right, thank you. So if you organize a conference, they have to invite you. What I want to talk about is we've heard so far today interesting and important legal questions about whether the FTC has rulemaking authority and to what extent and how it works with MAGMOS and all of that sort of thing. I want to kind of step back a little bit and say, let's just assume for argument's sake that they have the authority, either because the statute already provides it or because Congress wakes up tomorrow and says, you know what, we really ought to give the FTC this authority. So I'm not talking about the legal question. I'm talking about what would happen in a world where the FTC has that authority and there's no major question, concerns, or anything like that. We're just talking about the FTC as a serious rulemaker. And as I've seen the debate, I've kind of thought about that. What does it mean for the FTC if that were to happen? And I have 3 kind of big thoughts about that. And the first is ossification. And we've heard Jeff Leber's Mossification. It's a larger literature in administrative law about how hard it is especially for the really big rules, the really controversial rules, to get done, how much time it takes. There's an empirical debate about how long it really takes. I think Dick Baker is left. He has said even if the little ones don't take very long, the big ones take a long time. And I think most people agree with that. The really big rules either take a long time or a massive amount of agency resources, and often both. And it seems to me that if the FTC becomes a serious rulemaker, we need to be prepared for a very different type of institutional arrangement within the agency, unless Congress, as part of this magic where they just give them new authority, they also say, and we're going to give you unlimited resources. They're not the CFPB, so I don't think that's going to happen. But no, the question is, like, how does that work? And it seems they're going to have to allocate resources, and that's going to change things. We heard a little bit the concern about the consumer protection side that Commissioner Wilson was saying we're not seeing some of that being done because we've moved resources around, and I think that would be more permanent. You would have folks that's what they do. They're the rulemaking team, and it'd be a much larger team than it is now. When we hear about 13,000 comments and staff resources, well, that'll be more of a permanent part of the agency. And we can make decisions whether that's good or bad, but you should be prepared for a world where the agency spent a lot of time doing these things, and it could take years. And if we live in a world where we have back and forth presidential administrations, it means that, parties, it means maybe we don't get some of these rules. They get started and they never get finished. And there's a lot of resources that go into that. So I know a lot of people here are FTC experts. I would urge you to look at the administrative law literature on this and get up to speed on the ossification literature and the ossification debates, because the sort of fights that happen in other agencies that the FTC largely has been immune from will come to the FTC as well. So that's thought number one, ossification. Thought number two, we heard from Maureen Olsen, Commissioner Olhausen, and that's what I call zigzagging regulation. And what we've seen at the FTC's cousin agency, the FCC, look at the net neutrality / internet freedom debates. And you go back to, before 2000, the Clinton administration, or at least courts somewhat, had interpreted the law one way. Then the Bush administration came in and said, no, we're going to do it a different way. And they went through rulemaking and they made a rule, and this is how we're going to do it. And then the Obama administration came in and they said, no, we're not going to do that. We're going to undo what the Bush administration has just done, and we're going to do it a different way. And then the Trump administration came in and they said, no, we're going to go back to how they did it before with the Bush administration. And if the FCC ends up with the fifth commissioner, there's a pretty good chance we're going to go back, or something, other variation, and it just goes back and forth, back and forth, back and forth. And this isn't the only example of that. It's a pretty stark one that I think everybody can recognize. But look at environmental policy, look at immigration policy, look at labor policy. You see this where it goes back and forth, back and forth. If the FTC decides they're going to do the really big controversial stuff, they should be prepared to see it last for 4 or 8 years until the next administration comes in and they spend the first 2 years of the administration undoing what they just did. And it just goes back and forth. And, maybe we say that's not that big of a deal, it's not big of a problem. For certain types of industries, that is really bad, because the investment horizon to make sense whether to invest in new technologies is longer than 2 or 4 years. You need to have confidence that the scheme is going to be there during the duration of the project for you to invest in the project in the first place. So that strikes me, for certain industries in particular, as something you should be mindful of. In the FCC context, if they want broadband investment, it's almost just pick a rule. Congress should come in and just pick a rule, because so long as you have it goes back and forth, nobody knows what to invest in. And it seems to me that is a risk that the FTC will run, especially if they want to do the really big stuff. Small stuff, consensus-driven, probably you're not going to have that. But for the really big things, for which there is real, sincere opposition that's long-standing, you might think, well, we'll get this rulemaking authority and there we go. Well, the politics changes, parties change, and you'll live in a world where, maybe that works until it doesn't, and we just have back and forth, back and forth. And then the last piece of this is an expression Professor Tom McGarity has called administrative law as blood sport, which is a pretty striking image. But what he talks about is, in recent years, as Congress has become more polarized, we have seen when the political branches get involved in this, they just up the stakes on everything. So I'm sure right now the folks who have gone through the confirmation process for the FTC thinks it's really bad. But just wait. How much worse it can be. And if the stakes are really high, you're going to have massive pressure campaigns, massive fights. Again, I would say kind of look at the FCC as the cousin and just how much nastier that confirmation process can be than the FTC. That's just like one version of it. Professor McGarity also talks about lightning strike amendments. So you get a big appropriations bill, and as part of that, they throw on a little rider at the end saying this rule you've been working on for 2 years is now completely defunded. We don't change anything about the rest of the statute or whatever. We just take out this particular thing. And you see that kind of politics. But there's one more part of this that I think is particularly important, and that is the FTC in particular is subject to a variation of this, which is like the judicial version of administrative law as blood sport, which is the FTC is an independent agency and is regarded as an independent agency. If you look at Saylor Law and Collins, Humphrey's executor is on thin ice. And I know that, this isn't bragging because I got decimated, but I was asked to argue Collins, the most recent case on the president's removal power. And I put every argument I knew how to give the Supreme Court an off-ramp if they wanted to take an off-ramp from Saylor Law's broad language about the president's removal power. And there was no traction there. I think it's safe to say that Humphrey's executor is only there because of stare decisis. The more aggressive the FTC becomes, the risk of the court saying, wait a minute, if you're going to have fundamental change of the economy, the president better take responsibility for that. There's not going to be any separation where you can say like, oh, that's them, that's not me. That's something I worry. Now you say, well, maybe that doesn't matter, or in today's world, how real is independence anyway? But that just seems something to think about. So all three of those, I'm not saying they cut in favor or against. You might say, I hear all of that, and I still think it's important that the FTC becomes a serious rulemaker. And that's a defensible position. It just seems to me, though, that we need to think about those types of implications as the debate goes forward as to the future of the FTC as rulemaker. Those are my remarks.
Great, thank you so much. Erin?
Sure. So I'm going to very much pick up where Erin left off. I do not purport to be an FTC expert. Probably most of you in this room know more about the FTC than I do. My practice is more focused on constitutional litigation, and I've done a fair amount of separation of powers litigation. And I think Erin's absolutely right that the prospect of the FTC engaging in rulemaking brings to the forefront a lot of constitutional issues that are already pretty close to the surface for the court right now. And it's a kind of a fascinating story to think about the evolution of a lot of these kind of core doctrines that we're now talking about in terms of separation of powers, both when it comes to appointment and removal powers, also things like non-delegation doctrine. The FTC isn't just an independent agency. It's sort of like the original independent agency that was at issue in, the original case where some would say the court took a wrong turn here, Humphrey's executor, where the court said, we're going to allow restrictions on the president's removal power precisely because we think we're dealing with sort of an independent agency that's not really an executive agency. The FTC was also sort of in the backdrop of the Schechter-Poultry case back in the day that dealt with non-delegation principles, and the court kind of said, well, we're not as concerned about the FTC having powers that might be as unconstrained as another agency tasked with some of the same stuff, because we don't really think that they're being given the same kind of charge to go make law and go make rules. They have more of an adjudicative function. So if you kind of go back to early decisions when the Supreme Court is figuring out what it thinks about how to treat independent agencies for constitutional purposes, it's putting a lot of emphasis on what it thinks the FTC does and how it thinks its role is somewhat constrained. And part of what it was focusing on is, some of this is sort of adjudicative. It feels a little bit more like they're kind of helping out the courts, and we're going to have some judicial oversight, and maybe some of it feels a little legislative, but that's okay too, and that's why we feel like there doesn't need to be as much executive control here. And conversely, why we're not as concerned if we have broad delegations of power to this agency in the sense of not kind of telling them exactly what they're supposed to do because they're figuring out this, they're figuring out how to give contours to things like what is unfair methods of competition through a case-by-case adjudicative process. If you kind of fast forward today, one of the core things that has led the Supreme Court to start saying, we're just not just unwilling to extend Humphrey's executor, but let's talk about where we think it was wrong in its own terms. I don't think that the court, or really many of us, have the same conception of what the FTC is and does today that people had in kind of the first 10 years when the agency was coming into being. And for one, I don't think the courts have the same conception of being able to fit things neatly into buckets of this is a legislative role, this is an executive role, this is a judicial role. It's an agency that's essentially under the auspices of the executive branch, and for the Supreme Court's purposes these days, that's enough to make it executive. And if it's an executive agency, even if it's purportedly independent, that's where the court starts thinking there's something wrong with the idea of an executive agency that's not constrained in the way that we normally think the executive has to be. I think that has real implications specific to rulemaking and more generally to challenges you could face with the agency. First, as to rulemaking, it sounds like you've heard plenty today about whether the debate about how to interpret the statute and how to understand whether the agency has rulemaking. But I would certainly think a key component of that debate is essentially a constitutional avoidance argument that, okay, if the agency has rulemaking power, what is it out there that is constraining it at all and makes this not a classic non-delegation problem of Congress essentially giving an agency unlimited power to engage in any kind of rulemaking at once? And notably, if you go back to the Schechter-Poultry case, the actual agency charge that was at issue in that case was like almost identical to what the FTC says its charge is here. It was essentially to come up with fair modes of competition instead of unfair modes of competition. And the court thought that was a non-delegation problem. And it thought the FTC was different because it said, you kind of do adjudicative stuff. And if that's not what you're doing and you're kind of doing all of it and you're making rules, that brings much more to the forefront that concern. Now, 50, 40, 30, maybe even 10 years ago, you say, who cares? There is no non-delegation doctrine. The courts don't really enforce it. Even the Supreme Court doesn't seem serious about enforcing it. That's not the Supreme Court we have today. We know at this point that there's, at least 5, 6 justices who are very interested in this. Whether they know where they want to go with it is a little bit more of an open question. Whether they're unified in where they want to go with it is an open question. But I think the court is interested in thinking about where are the right places for us to look at this and think about it and figure out how to action, kind of put this doctrine into action. And to me, maybe that means that's one more reason courts are likely to be skeptical of the idea that the FTC has the rulemaking power in the first place, because that's an easy way to give force to the non-delegation doctrine without having to articulate actual limits on the non-delegation doctrine. You just say, we'd be really worried if they had it because there are no limits here. So that's all the more reason to go in their direction. But so I do think, just by virtue of kind of that you start to tee up some constitutional questions that have been more in the backdrop once you have rules coming out and the ability for courts to look at them. But then you have the broader issue of, creating more opportunities for the court to think about, is this agency constitutionally structured? And in some sense, the agency has been, the commission's been a little insulated from that, even as the court has, thought more about all of this and given a lot of signals that it doesn't think Humphreys is correct. One thing that has helped the FTC for a long time in avoiding these kinds of direct challenges is because it operates often primarily through adjudication, and so many of those cases settle out. You often don't get the challenges all the way to the end of the case and the opportunity to tee up the constitutional issues. Now, that actually is at issue in the case the Supreme Court's hearing this term, the Axon versus FTC case. We represent Axon in that case, and the basic argument, the issue in the case is, even in the adjudication context, should you be able to come in before you have to go through the entire process of the adjudication if your argument is not like, I think the agency's going to get this wrong, this is unfair, but I think this agency has no power constitutionally. It's unconstitutionally structured such that nothing it could ever do is consistent with the Constitution. If that's the nature of your challenge, should you be able to bring it at the forefront instead of having to wait until the end? And the challenges our client wants to bring there are challenges to the ALJ's removal authority, which ALJs are that FTC ALJs are pretty obviously unconstitutional under the Lucia. And when you put together like Free Enterprise Fund and Lucia, like you've got double four-clause removal, and you've got ALJs who operate functionally the same as SEC ALJs. So it's quite clear you have a problem with the ALJs. But we also have teed up the issue of should the court just overrule Humphrey's executor. So there may be a path that helps those issues get to the courts more quickly anyway. If as we hope the court holds that yes, you can bring these kind of things as a pre-enforcement challenge even when you're tied up in the administrative adjudicative process. But once you have the FTC going into the rulemaking sphere, not only are you creating more opportunities to drag them into court, you're kind of playing into the court's fear that, wow, we've got an agency that really is acting as executive, legislature, and adjudicator all under one auspices in some sort of independent way, which means nobody has any oversight over them. And I think to this current Supreme Court, that is not something that makes them feel good. It's something that makes them think, how are we going to rein this in? So I do think those are risks. If I were the commission myself, I'd be thinking about, what are we opening ourselves up to by virtue of being this aggressive? That clearly doesn't seem to be the way the commission's actually thinking, but that's my humble opinion.
Great, thank you so much. Blake, how about you?
Great, thank you. So first, just thanks to Erin for inviting me, and to Matt for helping to organize this great event. I've learned a lot. It's been a fascinating discussion. So, I want to focus my remarks today on some general administrative law themes, as well as the history and the political philosophy behind the federal regulatory state. But before I get to that, I wanted to just chime in on this theme that's been consistent throughout the day of how the FTC ought to act and what the risks are given the prospect of Supreme Court review. And to my mind, given the Supreme Court's posture, it almost doesn't matter how aggressive the FTC is, because whether the FTC proceeds by adjudication, as discussed in the Axon case coming up, or proceeds by rulemaking, whether it's a big rule or a small rule, you're going to get extreme skepticism about an independent agency wielding adjudicatory and rulemaking power from the Supreme Court. So it's not clear to me that from a litigation risk perspective, an agency really ought to bet its cards, bet the house on being more modest, because modesty might land you in the same unconstitutional posture either way. Before we had 2 new appointments to the Supreme Court, I don't think you would have had West Virginia v. EPA in a million years. A rule that, to my mind, and I think many other commentators, is squarely within the Clean Air Act, that was no longer in force, and was nonetheless held unlawful in an advisory opinion. But that's that's the world we're in, and so I think I'm not in the position of being a legal advisor to the FTC or any other agency, but it seems to me litigation risk, you might bracket it, that you might do what you think is your responsibility under the law and as good as a matter of policy, because the risk from the Supreme Court is going to be great no matter what you do. And so that ties into the history of the administrative state question, because these are political and legal questions, and the FTC and the administrative state is a political animal, and administrative law questions have gotten more political over time, and the FTC, it hails back to the progressive era, It is a progressive era agency, and that means something in particular. So it was created in response to the Supreme Court's, in the mind of Congress, overly constrictive interpretation of the Sherman Act. That the court, in the Standard Oil case, had misconstrued the statute, and they created the FTC Act in order to make sure that Congress's will was properly put into effect. That is the origin story of the FTC. And when the FTC was created, its purpose was not the relatively cramped view of antitrust that we have since the 1980s that's simply about efficiency and consumer welfare, but was more broadly, in the words of the Senate committee report reporting the bill, about the inherent rights of the people to preservation of fair and competitive markets. And the report insisted that the people of this country will not permit the courts to declare a policy for them. For then, if we do that, quote, we cease to be a government of law and become a government of men, and moreover, a very few men, and they appointed by the president. And so I think in a way we're right back where we were in 1914 when the FTC Act was created, where there is a court that is averse to the policies enacted by Congress. And the question is, what will Congress and what will the agencies created by Congress do in response to that? So a few aspects of progressive era regulatory lawmaking and policy. And so a big piece of this was the classic markers that we always talk about in administrative law about expertise. That this will be a body of experts informed by experience, as the court originally said about the Interstate Commerce Commission, which is one of the first regulatory agencies preceding the FTC. And so that's the piece of the progressive era that people often talk about, and it's quite important because it is about the reality that in our complex economy, policy must be made in reliance on people who know what they're talking about in the relevant subject matter. And the FTC is well equipped to do that. But that's not the sole aspect of progressive era administrative lawmaking when the agency was created. So prominent theorists of administration like Mary Parker Follett and John Dewey saw agencies as a crucial setting in which to engage the public in the formulation of regulations. So one prominent example of that was at the Forest Service, where the Forest Service held weeks-long deliberative hearings on grazing rights. And another example was at the FTC in their trade practice submittals. So as early as 1920, the Commission had developed an approach where it would invite particular industries to deliberate over the fairness of various practices in their industry and whether or not they were unfair. If the group reached near consensus on the lawfulness or not of a practice, then the Commission would accord, quote, great weight to that conclusion in its adjudication. This is from an excellent book that I brought with me from the library, a classic of administrative law, The Federal Trade Commission, A Study in Law and Procedure by Gerald Henderson. I recommend it to you if you're interested in the early history of the FTC. Some of the Commission's case law at the time described these trade practice submittals as conclusive unless rebutted by substantial evidence, although there was some back and forth on that question. And this procedure continued through the 1930s and onwards. And in the 1930s, in the midst of the New Deal, commentators described these submittals as rules or regulations. And they were not free from criticism that the rules were poorly drafted and they had too many exceptions, but nonetheless, rules they were. And the commentary on those rules went into some of the deliberations around the Administrative Procedure Act and the American Bar Association's Special Committee on Administrative Law. So I wouldn't go quite so far as to say that there was always what we would today call substantive rulemaking authority in the early FTC. It clearly wasn't that. But what you do see is a kind of evolving practice from at least the 1920s of having a deliberative participatory process to formulate unfair competition policy. And so, to my mind, what we're seeing today is the natural, logical outgrowth of that of that process. So the experience of the FTC Act ties in to the Administrative Procedure Act's notice and comment rulemaking provisions. So Congress designed the APA's rulemaking provisions in order to, quote, democratize the administrative process. That was the way the minority report of the Attorney General's Committee described the effort. The House committee reporting the APA contemplated that agencies would decide, quote, matters of great import through rulemaking, somewhat contrary to today's non-delegation doctrine, though they expected them to go beyond the bare minimum of the notice and comment in doing so. Even conservative opponents of the New Deal sought to encourage agencies to proceed by rulemaking, believing this to be a procedure more fair and just than case-by-case adjudication. And that same impulse motivated Judge Skelly Wright in National Petroleum Refiners to read the FTC Act as granting the Commission rulemaking authority. That's his, as Professor Merrill said earlier, that the crux of that argument is that rulemaking is better. Rulemaking is better than adjudication. And I know Professor Nielson has some scholarship pushing back against that, but I don't think it's too far to say that the mainstream position in administrative law for the past 40 years or so has been that rulemaking is the better way to make policy. It's also in the definition of rule in the APA that agencies can make, interpret, or prescribe law or policy by rulemaking. And so there's a lot to be said as a matter of fairness, of clarity, and in terms of democratic and open participation to making policy by way of rules. And that ties back into this question about the nitty-gritty legal question about whether the FTC has rulemaking authority. So as I said, I think there's an evolutionary historical argument, but I just want to come back to National Petroleum Refiners for a minute before I close out, because I think almost every administrative law class assigns National Petroleum Refiners. This is not an obscure case that people have forgotten, where a long time ago some district court said that maybe the FTC has rulemaking authority. No, this is the DC Circuit, the most important administrative law court in the country, short of the Supreme Court, holding that the FTC has substantive rulemaking authority under 6G. And note that many other agencies have been found to have substantive rulemaking authority based on those same general rulemaking grants. So the National Labor Relations Board, the Environmental Protection Agency. So the rule at issue in Chevron, one of the most important cases in administrative law, was a general rulemaking authority rule. So the question is, if that's not a rulemaking grant, what else is not a rulemaking grant? Are we going to take a slice out of all of these agencies with an opinion against the FTC? Well, perhaps, but that would be a massive sea change in the rules that Congress has relied on in enacting legislation over decades and decades at this point. So just to conclude, there's a lot of benefit to the notice and comment rulemaking process, as Elizabeth Wilkins' remarks suggest. It gives irregulated parties fair notice of the requirements to be imposed upon them, and it provides them with ample and open opportunity for broad public involvement and contestation over new policies, including the possibility of revisions to the policy before they are finalized. So one of the things that's important about the new rule, the proposed rule, and I suggest you read it if you haven't, is that it invites comment on particular aspects of the rule. We invite comment on if we've defined the exclusions in the correct way. Should they be broader? Should they be narrower? And so there's ample opportunity now to revise the policy in a way that's going to promote fair competition. And so, I'm hopeful that democratic process will be allowed to ongo without being stopped in its tracks. Thank you.
Great, thank you so much. Tim?
Yes, let me address this question. Can you guys hear me?
Yes.
Yeah, okay. We're talking about the future, and the future is not whether we're going to have rules or not. The future is what rules will we have? The idea that the FTC has not been enforcing rules in what President Biden called the failed 40 years, including the 8 years of the Obama-Biden administration. The issue is, do you believe, as has occurred in those 40 years at the Federal Trade Commission, do you believe that markets essentially have worked well? And are the basic rules of the game rules that work, but you need a cop on the beat, and the cop on the beat ought to enforce those rules? And the rules are so simple, we don't even think of them as rules, many people. They're the kind of rules you learn in the common law courses. Those are the consumer protection rules. The rules about not engaging in fraud, about keeping your promises, about not acting deceptively. Those are the heart of FTC consumer protection. Now, obviously, occasionally the FTC would supplement those rules. It would supplement them, for example, with default rules. The FTC's mail order rule was an early and important example, which answered the question of what was a reasonable time to deliver a package in the absence of a contractual specificity. On the antitrust side, the rules were equally simple. You don't engage in practices that raise prices, harm consumers. But the debate became, how do you gauge what are anti-competitive practices? And as I just wrote a tome for the American Enterprise Institute about the rules that were rejected, the rules of the populists, the rules that the neo-Brandisians praised. And those were rules that were not based on economics. Those were the rules of the Robinson-Patman Act, the rules of the Warren Court merger law, the rules that were thoroughly rejected, not just by the Chicago School, but most prominently by Harvard, led by Phil Arita and his most important pupil in many ways, also colleague, Justice Breyer. Justice Breyer was so important in all of this and such an aggressive proponent of modern antitrust law that when he was nominated to the Supreme Court, Ralph Nader and Lloyd Constantine opposed his confirmation on antitrust grounds. So much for the idea that it was the evil bearded Rasputin, as I heard one young neo-Brandisian who apparently had never seen a picture of the original Rasputin describe Bork. But anyway, so the question is, are we going to abandon the rules that were enforced in a bipartisan consensus? And the problem, there are multiple problems with what's going on. Elizabeth, one of the things Elizabeth said is, and we just heard from Blake, is the benefits of overreaching. Look, I've been involved. It's 50 years this year that I accepted a job at UCLA. I share that in common with Blake. At UCLA, I accepted an offer to work in the Federal Trade Commission, the first of my many jobs there. And I've seen how the agency functions best and how it functions worst. And you need to have a long view, and the long view is one where you can affect change, even in an area where the FTC is at bottom. For example, when I became chairman, the government had lost 7 previous hospital mergers in a row and had given up hospital mergers. Well, I thought there were a lot of anti-competitive hospital mergers, and we shouldn't give up. The government launched on what I thought would be a 10-year program, with long past my tenure, but it was a successful program. Put the government back on the map in hospital mergers. One of the problems with the current regime is repeating the mistakes of the 70s, is biting off way too many bet the agency endeavors. The keynote Elizabeth mentioned, do not call. Well, there are a couple responses to her points about do not call. One, and I suppose a flippant but true answer is, if you have an initiative where every member of Congress votes on a piece of legislation to overturn the court in the speed with which they declared war on Japan after the Pearl Harbor attack, then maybe that's an area on which you to stake your claims. But even there, even with that backing of Congress, the FTC was out on a limb. We would have, had we failed in the courts, despite the congressional backing, had we failed on constitutional grounds, and that was one of the grounds, we would have, that would have been our reputation. We would have tarnished the agency. So we were no doubt taking a big risk. And you shouldn't take many of those risks. You should only take a few. And a problem now is the agency is taking a lot of those risks, and they're not taking them in the measured, let's take a 10, 15-year plan. And I've seen this happen. When we came in the Reagan administration, I worked in the Reagan transition and was the director of both bureaus, as Svetlana said, fortunately not at the same time. Again, the idea was with the hope that the president would be reelected, with the hope that others would follow and agree with us. We knew that there was some very big things that had happened. The academy was the first to turn and reject what I call the populism. But the courts had already begun to follow. The FTC had a miserable court record. In antitrust, the FTC was losing almost 2/3 of its merger cases, and over 50% of its cases in total. And in those days, they litigated way more cases than they litigate now. So the government was the last. We had the foundations of making significant changes. And if you don't have those foundations, you need to do what we did in hospitals. You need to go out and create them. And I submit that what's happening now is a failure to recognize how you succeed in change. And I think the change they want is wrong substantively, but they're also going about it incorrectly procedurally. And having been one who has toiled in those vineyards of change, much of it successful in enacting the change, whether you agreed with it or not, of course, is another story. I think I speak with some knowledge on the subject. Thank you.
Great, thank you so much, Tim. Does anyone want to respond to anything they've heard so far on the panel?
No.
Alrighty, so let me ask some questions just based on the remarks so far. So someone made the statement that the FTC or rulemaking is appropriate where there's an expert body informed by experience, and I just wanted to ask a question with respect to some of the proposed rules. They do impact large swaths of the economy, and there are some to suggest that the FTC is actually not the expert agency based on a dearth of enforcement activity in those specific areas. So I wanted to ask each of you to respond to that. Is the FTC an expert agency in all things economy, or are there some things that perhaps the FTC is not?
So I'll go first. I guess I should have said this earlier. I'm actually in the pro-rulemaking camp. Usually it's odd. Usually you go to these and the conservative position is we don't like case-by-case adjudication because it's unpredictable and that raises due process fair notice concerns. And so usually I say like, no, I like rulemaking, and I like rulemaking even in the context of the FTC. I'm concerned about the FTC rulemaking because the power that they are using is so broad that it's not just rulemaking, it's rulemaking for Section 5, and that scares me, not the rulemaking part, it's the Section 5 part that scares me. So I'm sympathetic, but as to your specific question, that is a danger with rulemaking, but especially rulemaking with a really broad authority, is that you're going to get out in front of your skis and you're going to say things that you don't know. It's harder to do that in an adjudication context, or if you do, the damage is more limited because it's not everybody for the whole thing. So I like rulemaking because it's predictable, you have public engagement, it's prospective. I'm nervous when it strikes me that the agency doesn't have the ability to do it, or it's just too broad of authority for them to have that type of capacity. So that's my concern. If my advice to Congress would be, we could clear all of this. We can make it question. You could give them rulemaking authority, but I wouldn't do it the way that it is now. So the debate seems to me like it is what it is. We take the past as we have it. But if we really wanted to look forward to what this ought to be, we should think what the optimal solution would be. I don't think it would be define unfair. That just strikes me as not a good way. No agency is expert at that. It's impossible to be expert at that.
Erin?
Yeah, no, I pretty much forcefully agree with everything you just said. It's less the concern about there being something really wrong with agencies making rules. It really comes back to that kind of non-delegation instinct and concern about, what do they have the power to make rules about? And I think, to Blake's point about the idea that so many agencies are really just invoking completely generic rulemaking authority, that just sort of makes it worse because you have all these agencies stepping all over each other. You don't know whose lane is which. Every agency claims power so broad that they can do pretty much anything they want. And then you're kind of like, well, who's an expert in what? Are you all just experts in rulemaking? That's not a thing. You should be given some sort of real substantive charge from Congress about, look, here's something that, there's a reason we, Congress, don't feel like we can actually make all of the law in this area because it needs some expertise on some specific aspects of it. So here's what we want you to go and look at because it requires kind of an understanding that just is a little beyond our ken and we want some expertise backing it up, great. But when you have rules that kind of are divorced from anything like that, or are just, the kind of things that you're just going to be all over the map, and one day you're saying this is unfair, one day you're saying that's unfair, and oh, by the way, some other agency out there is going to sort of step in your lane and you're going to step in theirs because nobody has put any constraints on what it is that you're supposed to actually have some sort of expertise in and what it is that you're supposed to actually be making rules about with, some guardrails about hey, pick from a few options, not just make it up. That's where you start to get worried. And I think that's precisely where the courts start to get worried and why, to my mind, the concern that you do start to say, well, wow, if everybody can make any rules they want just because there's a provision in their organic statute that says they can make rules, geesh, maybe we do need to think a little bit harder about how to tie all of this back, not just for this agency, but for lots of others, to some sort of substantive charge with some limits. So, maybe it's not the FTC's responsibility to think about how its own actions might impact the broader administrative state, but I certainly think they have the potential to.
Great. Blake?
So first, Erin, Nielson, I didn't mean to mischaracterize your position on rulemaking versus adjudication. I thought you had some articles about that formal adjudication can be actually not as burdensome a method as sometimes portrayed.
Formal rulemaking.
Formal rulemaking. Okay, apologies. Yeah. On this question of general rulemaking authority and unfairness, I guess the question is, under when the courts are interpreting unfairness, is that okay? Is it okay for? I mean, we have under the Antitrust Acts that the court is interpreting this, I guess, a supposedly meaningless term, unfairness. Is that a delegation of legislative power? It hasn't been thought to be such. And so, to my mind, these are not meaningless terms. I mean, if you teach common law classes, we interpret what words like unfairness and reasonable mean on the basis of prior cases and on the basis of experience over time. And if you look at the rule in this case, which is based in part on the prior policy statement, which interprets what unfairness means under the FTC Act, it is based on the Commission's experience as well as on case law, and then it brings to bear empirical studies of the relevant labor markets to explain why the non-compete rules are anti-competitive. I'm not saying, I'm not an expert on the subject matter, so I can't say whether that is a good idea or not. But I think we should be careful about saying that terms like unfairness just just have no meaning, or that agencies can do whatever they want if they have broad rulemaking authority, because we shouldn't forget that notice and comment rulemaking under the Administrative Procedure Act means a great deal. To have to go through the notice and comment process and then explain the concise but no longer really concise statement of basis and purpose for your rule, and then be subject to arbitrary and capricious review under a relatively hard look, those are significant burdens. Part of my concern about where the court is these days is, instead of getting into the meat of actually reading the rule and looking at the arbitrary and capricious review, they engage in a much more casual form of statutory interpretation that says, well, if the question looks too big to us, we just don't think the agency has authority. And part of my concern is it's not clear what agencies are supposed to do with that. What is big? What's small? It's kind of a roving license to just strike down agency action that you don't like. In an environment like that, I think agencies have to think of their rulemaking not in terms of just, well, is this rule going to be accepted or not? They have to think about their action in this dynamic system of separation of powers, where they are speaking not just to the courts, but also to Congress and to the people. And if you end up in a situation where the court is invalidating lots of rules and rulemaking provisions and statutes based on spurious interpretation, then it's going to require legislative response. And that, I hope we don't end up in that space. But ultimately, that is the way the clock turns in a system of checks and balances.
Great, Tim.
Yes. Look, if you go back before the modern administrative law, and tie this in with Brandeis and the concern of the early progressives and the early populists, we had the modern economy develop, and the modern economy developed under the common law. Now there had to be some changes in the common law. Modern tort law developed, but it was that economic behemoth, which in 1936 FDR went populist, called them the economic royalists. 4.5 years later, with war in Europe and the threat of Japan looming in the Pacific, he now was talking about the arsenal of democracy. And if those early progressives and populists had their way, and there hadn't been an arsenal democracy, who knows what would have happened in World War II? And that was without the modern regulatory state. Now there were some things of the modern regulatory state that have been helpful. In environmental law, despite the criticisms on both the left and the right, has seen enormous progress. I was born in northeastern Ohio, where you couldn't swim and fish in Lake Erie, and the rivers burned. It's a long time ago, and none of that is true anymore. Greg Easterbrook, Frank's brother, did a book a few decades ago about about the tremendous benefits from environmental regulation. I think it could have been done a lot more efficiently and a lot better. But there have been benefits from the administrative state. But the common law approach that the FTC has applied and using words like unfairness, and there's a statutory definition of unfairness. The FTC had a long history. It first started when Dick Posner, of all people, at age 25, wrote a 3-part definition for unfairness, which 2 parts eventually got jettisoned, and then a statute was enacted in 1994, which is an economic cost-benefit test. The FTC has started over. The FTC has 2 U's. Apologies to my cousin Vinny. They have a U in unfair methods of competition and a U in unfair deceptive acts or practices. It's the latter, the UDAP, that has the definition. The U in unfair methods that end of last year, they started over again with a statement that took the worst part of what Posner had done in 1964. So there's a sharp contrast between the two, between the way the agency has those two versions of unfairness. So obviously you can do unfairness the wrong way. I don't doubt that, but I'm not afraid of the concept. And as Blake said, words like reasonableness dominate the common law. So.
Okay, so we have time for audience questions. Does anyone have any questions for the panelists? Baron?
Blake, thanks for recommending that Henderson book. Looking for a resource like that was really quite apt. You make really good arguments, and Erin, I think, shares a lot of your views about the merits of rulemaking. But of course, the real question before the court, when this question works its way up to the Supreme Court, has nothing to do with the merits of rulemaking. The question, first and foremost, is going to be, what does the text of the Act of 1914 say, as it would have been understood at the time? And you noted quite correctly that same language about making rules and regulations to carry out the provisions of the Act, it does indeed appear in many other statutes, but you've left out one very critical difference, which Professor Merrill has documented quite well, which is the text of those, that isolated provision might be the same, but it's accompanied in every other circumstance in the cases that in the statutes that we pointed to by an equally clear grant of civil penalty or other penalty authority to an agency that imposes some consequence. In the case of the FCC, that might be the deprivation of a broadcast license, for example. And of course, the FTC Act of 1914 has no such provision. There's no penalty. There's no negative consequence. The only power that the agency had for violations of the Act itself was to get injunctive relief. So when we say that these are similar provisions, on their face, they're just not. It's the same language in a 2-part structure, that one part of which, 6G, is in the FTC Act of 1914, and is a different thing in all these other statutes. And Professor Merrill's documented quite clearly that the convention at the time understood very clearly that when Congress intended to grant substantive rulemaking power, it married those 2 provisions together. So it's easy to distinguish those other statutes from 6G. It's not going to cause the sky to fall. The court simply says in this particular case where the commission was given power just to make housekeeping rules in this provision and no power to impose any other consequence for violating rules, let alone the Act, that can't be interpreted as grant substantive rulemaking power. So what do you think the court will say in addressing, before you get to these big picture questions of non-delegational major questions, what do you think that they will say about the textualist question of how to interpret 6G in the absence of any other enforcement provision in the original Act?
Yeah, well, it's interesting. If you look at the... Oh, should I summarize it? Right. So there's this whole question. I mean, so Professor Merrill has an important, famous article about the original convention around substantive rulemaking authority. The argument being that prior to national petroleum refiners and store broadcasting, and a third case I'm blanking on. Thorpe, the standard interpretation of statutes and the drafting convention was that if they include in the rulemaking provision a penalty, that is a substantive rule, whereas if it doesn't, then it is an interpretive rule, roughly speaking. And so, I would be foolish to challenge Professor Merrill on the historical record, especially not without having dug into it in detail myself. But one point of interesting evidence on that with regard to the FTC specifically is that there was a discussion in the FTC Act about making more specific the rulemaking provisions of Section 6 with regard to auditing of the accounts of corporations. And it was clear in the legislative discussion that they intended that to be a binding regulation, but nowhere in the proposed text does it include a penalty. So that's just one piece of evidence to suggest that it might be more complicated, that it's not always the case that that Congress believes there has to be penalty language in order for it to be a rule with the force of law. I mean, there's been lots of discussion today about how to properly interpret Section 6G. I'll just say that I'm on board with Professor Lau's interpretation that if you look at National Petroleum Refiners that said that you have rulemaking authority for the FTC with regard to both unfair competition and unfair and deceptive practices. And then Magnuson Moss follows, and it prescribes procedures for the unfair practices, and says it's not disturbing any rulemaking authority with regard to unfair competition. The natural construction of that is that Congress ratified National Petroleum's conclusion that the FTC had rulemaking authority with regard to unfair competition. Now, I'm not going to say that that's the only way to read the statute. I do think that there's a reasonable debate to be had on this point, but I do think that is the better construction.
Great. Go ahead.
Yeah, the amendment you're referring to was proposed by Congressman Lafferty, and it was rejected. So.
Right, what I'm saying, yeah.
I can't draw any inferences about Congress's belief that you could have a legislative rule without enforcement based on the fact that they rejected this kind of amendment. Anyway.
Well, the point was just, the point is that if they thought that it was binding language, and everybody thought that in the discussion, but it didn't include a penalty, I think that is significant evidence.
Well, I know what everybody else thought. They just voted it down. Anyway, I guess the point I wanted to make is I'm not an enemy of rulemaking either. I think, I'm a big fan of rulemaking, certainly in the environmental context, maybe even in the deceptive practices area. It makes a lot of sense. The big question is, I guess, does rulemaking make sense in the antitrust and in the competition context? And so I think, picking up on Commissioner Wilson's points this morning and Tim Muris's points, that it really depends on whether you think the market of its own solves most of the problems. There have to be some restrictions, obviously, on cartels and restrictions on mergers to monopolies and so forth. But if you think the market will sort of self-correct for the most part, all you need is some kind of adjudicated mechanism to sort of weed out the bad actors. If you think there's some pervasive externality problem, as with environmental problems and so forth, then maybe you need the more powerful government presence like rulemaking. But just simply say that we need rulemaking in antitrust areas because we like the government decision-making better than the market's decision-making seems to beg the question. It's like you quoted this nice statement from the Senate report to the effect that, in 1914, Congress was upset with a small number of men appointed by the president deciding what's good for society. Well, that could be a description of the FTC commission right now,
Women, though.
What?
Women, though.
Women.
Yeah.
Anyway, some progress has been made. But still the point would be, sort of like top-down directions as to how the economy should be structured. And the big question is whether you think in competition matters that, the market is really rotten and produces all sorts of bad results, and we need to have the government overseeing everything with its broad rulemaking authority. I think most people would argue that we don't need to have the government setting prices or wages or doing things like that because the market does a pretty good job at those things. So the question really, the substantive question, putting aside all these legalisms, is, do we really think that having, an agency making rules about competition is necessary given the proclivities of ordinary market mechanisms to self-correct, or do we need a more powerful engine of collective oversight? I come down and thought that we've had adjudication now for over 100 years. It seems to work largely pretty well. We have some per se rules in narrow context. We have the merger guidelines that work pretty well. I don't really think that some kind of omnibus rulemaking authority on the part of the FTC is necessary in order to make a better world. But other people disagree.
Well, I mean, again, I'm not an expert on antitrust, and I do have my views on it, but I guess I'll bracket those and just say that elections have consequences, and this is part of the Biden administration's agenda, and the chair has connected the FTC's agenda to the Biden administration, which is interesting for this whole question of presidential accountability, I think. To the extent we care about democratic control over our social structure, and that's written into our constitutional regime, that's a good thing.
If I could just offer one, throw a little bit of the legalism back into it. I do think one of the interesting dynamics, when you think about the role of the courts in this, you have to think not just about the role from the constitutional standard, but also kind of how the court's thinking about antitrust law. And boy, you got a profound disconnect when you've got a Supreme Court that for decades has been moving in the direction of we trust the markets. I mean, that's just going to make it that much harder because there's going to be distrust in the substantive rules on top of distrust in the rulemaking among many of the folks that you've got up there now.
Anything else? Okay, any other questions? Alrighty, seeing no questions, please join me in thanking the panel.
Sure. And that is the conference. Thank you so much for coming. Thank you so much for our helpers over here who did all the tech for us. Thank you for coming, and good luck, everybody.